Under Arizona law, both spouses have an ownership interest in the community assets they acquired during their marriage. The right to receive compensation from an employer also constitutes community property, whereas just a mere expectation to receive money does not constitute an asset that is subject to being divided by an Arizona divorce court. The Arizona Supreme Court, in the case of Van Loan versus Van Loan, had to determine whether an unvested interest in a military pension constituted community property that should have been divided between the parties. At the time of the parties' divorce, the husband had served 19 years and 5 months in the Air Force, but his pension did not vest until he had served 20 years. The husband argued that because he had not completed 20 years of military service at the time of the divorce, he didn't have a vested right to the retirement benefits when the parties' divorce went through. The husband, therefore, claimed the community didn't have one either, and the divorce court could not award any part of it to Verna. Jack claimed that until he served the full 20 years, he only had an expectancy interest, not a property interest, in that pension. The Arizona Supreme Court said that the touchstone of the case was not whether the husband's pension rights were vested at the time of the divorce, but whether his interests were a property interest or simply an expectation. It noted that the pension plans are a form of deferred compensation to employees for their services. Just like take-home pay, an interest in a retirement plan earned during marriage belongs to the community. Since a pension plan is one of the reasons a person agrees to work in a particular job, the plan is a contractual right that comes from the employment contract. Now, the terms of the pension cannot be changed or the benefits taken away from the employee as long as he fulfills his service requirements. This is true even if the employee has not yet worked enough years to be eligible for the retirement benefits. When an employee has a retirement plan at work but has not yet worked enough years to receive it, it cannot be viewed as a mere expectancy interest. Under Arizona law, expectancy describes an interest of a person who hopes to receive a financial gift in the future but doesn't have a legal right to it. For example, if someone thinks he'll inherit money under his parents' will, it is an expectancy interest, not a right, since his parents can change their will at any time. The defining characteristic of an expectancy is that the person holding it does not have an enforceable right to it. A contractual right, on the other hand, is an enforceable right and therefore a form of community property. Because of that, both the husband and the wife had a property interest in husband's unvested pension. To the extent the property right was earned during Jack and Verna's marriage, a divorce court may properly divide it between the couple.